Legal and Privacy Brief for April 24, 2026. Anne Arundel Dermatology agreed to $2.4 million to settle breach claims, case No. 125 CV 2274 GLR. Supreme Court rejected military contractor immunity for war zone negligence and ruled the 30-day removal deadline to federal court is mandatory. CISA, the Cybersecurity and Infrastructure Security Agency, disclosed that a federal agency was breached through Cisco firewall vulnerabilities, with Firestarter malware maintaining access from September 2025 through March 2026. Here's the full breakdown of today's top legal and privacy stories. Next section, Enforcement Actions. CISA, the Cybersecurity and Infrastructure Security Agency, Federal Agency Breach, CVE 2025-30333, CVE 2025-20362. CISA disclosed that an unnamed federal civilian agency was breached in September 2025 through two Cisco Adaptive Security Appliance vulnerabilities. Attackers deployed Firestarter malware that maintained persistent access through March 2026 without re-exploiting the original vulnerabilities. A second malware strain, LineViper, created illegitimate VPN sessions bypassing authentication policies. The attackers accessed administrative credentials, certificates, and private keys, and used federal accounts that were dormant but not deactivated. CISA issued updated directives requiring all federal civilian agencies to submit forensic data and check for infection. Compliance action. Organizations using Cisco Firepower or ASA devices must immediately patch CVE 2025-30333 and CVE 2025-20362. Audit for Firestarter indicators, review dormant accounts for deactivation, and implement monitoring for unauthorized VPN sessions. Deactivate inactive accounts across all systems. Sources: The Record. U.S. sanctions Cambodian senator for scam compound operations. The Treasury Department sanctioned Cambodian Senator Kok and 28 associates for operating scam compounds that stole millions from U.S. victims. Kok and's Crown Resorts properties in Poipet, Sihanoukville, and Bavit were converted into facilities for digital asset investment fraud. Trafficking victims at these compounds were forced to execute scams and beaten if they failed to contact a certain number of victims daily. At least $1.3 million in scam proceeds traced to accounts controlled by associate Luo Hong. 8 U.S. residents pleaded guilty to money laundering roles in the scheme, with one defendant fleeing after cutting off his ankle monitor. Total victim funds deposited exceeded $73.6 million. Compliance action. Financial institutions must screen transactions against the newly sanctioned entities and individuals, review cryptocurrency investment, fraud patterns, and implement enhanced due diligence for cross-border transfers to Cambodia. Sources: The Record. IRS ICE data sharing impacts tax compliance. The Trump administration eliminated the firewall between IRS and ICE, allowing immigration enforcement access to tax data. Yale Budget Lab estimates the IRS will lose between $147 billion and $479 billion over the next decade as immigrants disengage from formal tax filing. One Maryland accounting firm reported losing 550 clients, 15% of customer base, as tax day approached. Immigrants account for higher employment rates and generate more tax revenue per capita than U.S.-born populations by working more cumulative hours, despite lower hourly wages. Without immigrant tax contributions, public debt would exceed 200% of GDP. Sources: TechDirt. Next section, Litigation Updates. $2.4 M. Anne Arundel Dermatology Data Breach Settlement, Case No. 1-25 CV 2274 GLR. Anne Arundel Dermatology agreed to a $2.4 million class action settlement for December 2025 data breach that compromised patient PII and PHI across Virginia, North Carolina, South Carolina, and Maryland locations. Class members who experienced documented out-of-pocket losses can receive up to $5,000 in reimbursement for fraud losses, bank charges, and credit expenses. Class members without documented losses receive an estimated $100 pro rata payment. All class members receive 3 years of medical data monitoring services, including credit monitoring, dark web scanning, and $1 million identity theft insurance. Claims deadline is July 8, 2026, with final approval hearing July 16, 2026. Compliance action. Healthcare entities should review cybersecurity measures against the claims in this case. Failure to implement reasonable cybersecurity measures. Document breach prevention efforts and incident response plans to defend against similar claims. Sources: Top class actions. Adobe wiretap class action over Optum patient communications, case no. 5 to 26 CV 2958. Plaintiff Gil Hodges filed a class action in California federal court, alleging Adobe intercepted, recorded, and eavesdropped on patient communications on Optum's website through its Marketo Engage platform. The complaint claims Adobe used tracking technology to intercept PII and PHI without consent, duplicating and transmitting patient data to Adobe servers in real time. The lawsuit alleges violations of the Federal Wiretap Act and California's Invasion of Privacy Act, seeking statutory damages of $5,000 per violation under California law, plus Federal Wiretap Act damages. The case follows Adobe's $150 million settlement with DOJ, the Department of Justice, over deceptive subscription practices violating the Restore Online Shoppers Confidence Act. Compliance action. Organizations using third-party marketing platforms, Marketo, HubSpot, Salesforce Marketing Cloud, must audit tracking technologies on healthcare and sensitive data websites. Obtain explicit consent before implementing session recording or behavioral tracking that captures PII/PHI. Sources: top class actions. Supreme Court rejects military contractor immunity, Hensley v. Fluor Corporation. The Supreme Court ruled that military contractors do not have absolute immunity for negligent mistakes in active war zones. The case arose from a 2016 suicide bombing at Bagram Airfield in Afghanistan, perpetrated by a former Taliban member working as a Fluor employee. Survivors argued Fluor's failure to follow military rules about tracking Native employees made it responsible for the attack. Justice Clarence Thomas wrote that state tort law is not preempted when contractor conduct was not authorized by, but was even contrary to, federal instructions. Military officials found Fluor failed in its contractual obligations. The ruling distinguishes Boyle v. United Technologies Corp., which recognized a defense only when the government directed the contractor to do the very thing that is the subject of the claim. Compliance action. Federal contractors operating in conflict zones must strictly document adherence to military security protocols. Implement compliance monitoring systems to demonstrate following federal instructions. Liability insurance policies should be reviewed for war zone coverage exclusions. Sources: Scotto S. blog. 30-day federal court removal deadline is mandatory in Bridge Energy, LPV, Nestle. The Supreme Court unanimously held that 28 U.S.C. Section 1446b1's 30-day deadline for removing cases from state to federal court is mandatory and not subject to equitable tolling. Justice Sonia Sotomayor wrote that district courts cannot extend the deadline based on extenuating circumstances, and Bridge filed its removal notice 857 days after the deadline expired, arguing exceptional circumstances warranted tolling due to federal issues and potential collision with another pending federal case. The Sixth Circuit reversed the district court's acceptance of the late removal, and the Supreme Court affirmed in a 14-page unanimous opinion. Compliance action. Corporate counsel must strictly track 30-day removal deadlines from state court service. Implement calendar systems with multiple alerts before the deadline. No exceptions will be granted regardless of case complexity or parallel federal proceedings. Sources: Scotto S. blog. Overpayment claims require plausible economic injury, Monahan v. Southwest Airlines Co., 2026 WL 1,035,070. The Fifth Circuit dismissed overpayment claims by airline passengers who never flew on Boeing MAX-8 aircraft, but alleged Southwest breached purchase agreements by operating the planes before the FAA grounding. Plaintiffs claimed tickets were less valuable because Southwest could have placed them on a MAX-8. The court held the overpayment theory was implausible because Southwest would have charged higher prices had it known about defects and removed MAX-8s from routes, decreasing available seats. The ruling reaffirms that invoking overpayment does not establish Article Roman III standing without plausible allegations of actual economic injury. Sources: Inside Class Actions. Honda Fuel Pump Settlement, Oliver v. American Honda Motor Co. Case No. 5 to 20 CV 666, Honda reached a proposed class action settlement covering 6.2 million vehicles equipped with allegedly defective Denso fuel pumps that could cause stalling while driving. The settlement covers 2021 to 2025 Honda vehicles including Escalade, Silverado, Tahoe, Suburban, Sierra, Yukon models. Honda will extend warranty coverage to 15 years or 150,000 miles, whichever comes first. Vehicles beyond that limit remain eligible for 90 days after final approval. The settlement provides reimbursement for out-of-pocket repair expenses and free loaner vehicles during repairs. The case has been pending for 6 years since April 2020, shortly after Honda's recall. Sources: Top Class Actions. Next section: Regulatory Guidance. France DNS blocking orders extended to third-party resolvers. A Paris Court of Appeal validated DNS blocking orders requiring Google, Cloudflare, and Cisco to block pirate sites through their third-party DNS resolvers. The ruling goes beyond traditional ISP resolver blocking that France has required for years. The court rejected arguments that DNS resolvers serve a neutral and passive function, similar to a phone book, holding that the ability to help block access is sufficient under Article L. 33310 of the French Sport Code, regardless of liability. The court ruled that DNS blocking is proportionate as long as it stops some subset of users, despite being easily circumvented by VPNs or alternative resolvers. Canal Plus brought the case arguing users were switching to third-party DNS to circumvent ISP-level blocking. Compliance action. DNS resolver operators should monitor French court orders and prepare compliance procedures. Organizations relying on third-party DNS for privacy or security should implement backup resolution methods. VPN providers may see increased demand in France. Sources: TechDirt. Next section, privacy developments. FBI extracts deleted signal messages from iPhone notification database. The FBI forensically extracted incoming signal messages from a defendant's iPhone even after the app was deleted by accessing copies stored in the device's push notification database. The extraction demonstrates that secure messaging apps leave data artifacts in unexpected system locations when forensic tools are used with physical device access. Signal already implemented changes to address notification data retention, but the case highlights limitations of encryption when devices are physically compromised. Compliance action. Organizations relying on encrypted messaging for privileged communications must implement mobile device management policies requiring regular cache clearing. Train employees that deletion of messaging apps does not eliminate forensic recovery risks. Consider endpoint security tools that wipe notification databases. Sources: Schneier on security. Surveillance companies exploit telecom systems for location tracking. Citizen Lab researchers identified surveillance vendors exploiting SS7 and diameter protocol weaknesses to secretly track targets' locations by posing as cellular providers. One campaign sent malicious hidden SMS commands to turn devices into covert tracking beacons. Another exploited SS7 protocols in 3G networks, which lack source verification, authentication, and encryption. Diameter protocols for 4G/5G networks were also attacked because operators failed to implement security protections. 3 mobile networks repeatedly appear as surveillance entry and transit points, functioning as gateways for threat actors. Evidence suggests an Israeli surveillance company may be behind the campaigns based on traffic routing to Israel. Researchers described the attacks as massive amounts of unauthorized traffic, with over 90% generated by third parties accessing mobile signaling environments. Compliance action. Telecom operators must implement diameter security protections and audit SS7 interconnection agreements. Organizations with high-value targets should assume location data is accessible to surveillance vendors and implement operational security measures accordingly. Sources: The Record. Wireless carriers challenge FCC location data fines. Major wireless carriers AT&T, Verizon, and T-Mobile face $196 million in FCC fines. $91 M T-Mobile, $57 M AT&T, $48 M Verizon, for selling user location data to third parties without adequate safeguards from 2014 to 2019. The Fifth Circuit vacated AT&T's fines in 2025, ruling that FCC penalties violated the Seventh Amendment right to jury trial. The Supreme Court heard arguments and expressed skepticism about the carrier's claims, but the FCC indicated it may change forfeiture order language to clarify fines are non-binding until after jury trial. Justice Brett Kavanaugh told carriers, "It seems like you've won on the law going forward, one way or the other." The FCC is defending some enforcement authority, while Brendan Carr seeks to retain power to force corporate compliance with administration priorities. Compliance action. Organizations selling or sharing location data should prepare for potential state-level enforcement as federal FCC authority erodes. Implement opt-in consent mechanisms and audit third-party data sharing agreements. Document user consent for location data access regardless of current regulatory uncertainty. Sources: TechDirt. Next section, policy changes. CIS a director nomination, withdrawn after 13-month stall. Sean Planky withdrew from consideration to lead CIS after his nomination stalled for over a year in the Senate. Planky was nominated in March 2025, but faced holds from Senator Ron Wyden Dior due to CISA's refusal to publicly release an unclassified report on telecom cyber weaknesses, and from Senator Rick Scott RFL, over Coast Guard work concerns. CIS is currently run by Acting Director Nick Anderson. The agency lost approximately 30% of its workforce to layoffs and experienced furloughs during the recent government shutdown. CIS has operated without Senate-confirmed leadership for over a year during heightened cyber threats. Compliance action. Organizations should not expect consistent federal cybersecurity guidance or partnership programs until CIS leadership is confirmed. Implement cybersecurity programs based on existing NIST, the National Institute of Standards and Technology, frameworks rather than waiting for CIS directives. Sources: The Record. China-linked hackers use Slack, Discord for Mongolian government espionage. Asset researchers identified a previously undocumented China-line threat actor named Gopher Whisper that targeted a Mongolian government entity using Discord, Slack, and Microsoft 365 Outlook for command and control operations. The group deployed lax Gopher backdoor malware on roughly a dozen government systems since November 2023. Custom tools written in Go included Rat Gopher, Box of Friends, Jab Gopher Injector, Friend Delivery Loader, and SLore Door Backdoor. The data exfiltration tool Compact Gopher compressed files and uploaded them to File. EO. The hackers used legitimate online services to conceal malicious activity from network monitoring. Compliance action. Network security teams must monitor traffic to collaboration platforms, Slack, Discord, Microsoft Teams, for anomalous patterns indicating command and control abuse. Implement application whitelisting and egress filtering to file sharing services. Review acceptable use policies for collaboration tools. Sources: The Record. Next section, Compliance Takeaways. Patch Cisco ASA/Firepower devices immediately for CVE 2025-30333 and CVE 2025-20362. Firestarter malware maintains persistent access even after patching if deployed before September 25, 2025. Run CISA's detection tools and deactivate all dormant administrative accounts. Review third-party marketing platform tracking on any website handling PII or PHI. The Adobe V. Optum Case 5-26 CV 2000-958 exposes Federal Wiretap Act and California Invasion of Privacy Act liability for session recording without explicit consent. Audit Marketo, HubSpot, and similar platforms for real-time data interception capabilities. Implement 30-day removal deadline tracking systems following Enbridge v. Nestle. The Supreme Court's unanimous ruling eliminates equitable tolling regardless of case complexity or parallel federal proceedings. Corporate counsel must calendar multiple alerts before the deadline with no exceptions. Audit encrypted messaging endpoint security. FBI extraction of deleted signal messages from iPhone notification databases demonstrates forensic recovery risks. Deploy MDM policies requiring notification cache clearing and train employees that app deletion does not eliminate data artifacts. Screen transactions against Cambodian scam compound sanctions. Treasury sanctioned Senator Kok An and 28 associates involved in digital asset investment fraud operations. Financial institutions must implement enhanced due diligence for Cambodia cross-border transfers and cryptocurrency investment patterns associated with the $73.6 million scheme. That concludes today's legal and privacy brief. From Carolina, Clear Tech. For informational purposes only, not legal advice.